Good afternoon, Your Honors. James Terry of Zetlin and De Chiara, LLP, for the Trustees of Columbia. Your Honors, the motion court scrupulously adhered to the jurisprudence established by this court in granting these dismissals. That goes from the LaDuca and 2013 Bovis decisions through the two affirmances in WDF, which, by the way, is 5 Star's affiliate company, and continuing on to this year, to the 2 federated decisions to which Mr. Richards made reference, both of which cited WDF, both of which unanimously upheld the dismissal of the claims pursuant to the no damage for delay clause. Now, many of the alleged delays...
What does the plaintiff have to allege here in order to at least get past the pleading stage on these no damages for delay? Because certainly there were things that were not anticipated, but what do they have to allege?
They have to establish one of allegations that rise to the level of a Carino exception. All of these issues concerning the access to the property all have been unanimously resolved as inept administration, poor planning of a project. I mean, there is the exception for fundamental contractual obligations that are express. So if they wanted to have an express obligation of, for example, a critical path method schedule, that's what could be put into the contract. If that's violated, that becomes something that becomes actionable. But the allegations that were before the motion court did not rise in any shape to that level. 5 Star recently made exactly the same arguments before Justice Sherwood, and they were rejected, both no damage for delay and the cardinal change in 5 Star versus Plaza Construction, which was reported rather after our brief was prepared. The site is 2020 Westlaw 4464334, decided this year. Pretty much exactly the same allegations were made and were rejected. The question was asked, how does this case differ from WDF? Your Honor asked that question. The answer is really not much at all. The allegations are very similar. Some of the delays are exactly the same.
But isn't counsel correct that his client is a core and shell subcontractor and is entitled to be doing his work alone? Would that be sufficient to say that, to bring? No,
Your Honor, that's really a distinction without a meaningful difference. Both of those companies had defined scopes of work to be done within a certain period of time. Both were delayed. If you take the argument that's been made by the appellant and carry it out, then the only party against whom a no damage for delay clause could be applied is the last trade on the line of progression. Because every other trade could say, well, I never expected to have to work with those follow-on trades. And that would basically render the entire no damage for delay clause useless. The fact of the matter is that they had exactly the same delays in many respects. Late superstructure completion, the need to replace the concrete flooring, causing them delays, the absence of the critical path method schedule, causing them delays. Some of them are exactly the same, others similar. With respect to the negotiation of this contract, this was a negotiated contract. The contract does have a rider, and the rider amended not only the no damage for delay clause, but other provisions of the agreement.
So, plaintiff did allege in the 5th cause of action that because of this delay, there had to be resequencing of the core and shell work, and that this, at least they allege, drastically changed the nature of their original scope of work. Is that enough?
No, Your Honor, because it doesn't.
Why not?
No, because the cardinal change test is the essential identity, the main purpose of the work changed. And that didn't happen here.
Well, what would constitute an essential change of the work? I mean, they're there to do the kind of work they're going to do. They're not going to become a different kind of contractor overnight.
If you tell a core and shell contractor, I want you to take on the fit-out work, that's something very different. If you tell a contractor, we originally thought this was going to be a 6-story building, it's going to be a 9-story building, we want you to stay to your contract terms for that. That would be considered a cardinal change. But the motion court correctly found that what was alleged here did not change the essential nature of the contract. That's why it was capable of being subsumed within Article 13, the changes clause. The analysis was scrupulously made and it was correct.
Okay, thank you very much. Counsel, we'll hear from the attorney for Lend Lease.
I appreciate your time. Thank you, Your Honor.